So they say Trump now seeks leave from this court to file a second notice. Now, the judge is saying, I already denied you the first time, so why are you coming back here a second time again? Now, I held in my order before, about a year and 2 months ago, that hush money paid to an adult film star is not related to a president's official acts, which is this judge. Who is this judge? Alvin Hellerstein. Okay. Danny Chin was appointed by Bill Clinton and Barack Obama. Susan Carney was appointed by Obama. And Myrna Perez was appointed by Biden. Oh no. Isn't that just terrible? Donald Trump's attempt to remove his case from Judge Merchan in New York, to take it away from him before the sentencing occurs on September 18th, has been rejected by the federal courts. And prosecutors are pretty happy about this because they want to keep that scheduling date on track. We see here that Alvin Bragg's office in this New York criminal prosecution is also responding in a letter saying that we want to keep this train on the track. Let's see what this big one is. You can see this is the order denying Trump's motion for leave to file the removal papers. Now, Trump has already been denied this once before, and he just got denied again. It says former President Trump, this is what the judge says, is again seeking to remove the criminal case against him, to take it away from, in our opinion, the very biased Judge Merchan, the man who donated to Joe Biden, the man who criticized Trump to his daughter that she discussed on a podcast, the same man whose daughter works for Democrats as co-owner of Authentic Campaigns or partner or whatever her role is there. It's a big one. And they've made millions of dollars from Democrats and raised and solicited funds on the back of Trump's prosecution in this courtroom. So he wants to remove it, take it up to the feds. Now, upon removal, this judge says, as the district judge to whom this case was assigned, my task was to examine this promptly. And he says, if it clearly appears on the face of the notice that removal should not be permitted, then I am to make an order for summary remand. And if it's not appropriate, then I'll have an evidentiary hearing and then we can discuss this later. Now, since Trump filed his notice after he was tried, all right, so Trump is saying, we want to remove this from Merchan's court before the sentencing. The process is still ongoing. The sentencing has not occurred yet. They say Trump must show good cause and seek leave from the district court to file the notice at a later time. Now, the second notice may only argue the things. So they say Trump now seeks leave from this court to file a second notice. Now, the judge is saying, I already denied you the first time, so why are you coming back here a second time again? Saying, well, if you have good cause, I can accept it, but let me go through this. They say Trump says New York courts were biased against him and it was an improper trial. And this is obviously true. Now, as support for this argument, they say Trump says that Judge Merchan had a conflict of interest, in presiding over the trial. Why? Because the judge's daughter gave some statements about her father's views of the politician's use of Twitter. Said that on a podcast. Lauren was saying, my dad thinks it's kind of improper, unbecoming of a president to communicate this way using X. Also, the judge is biased because the judge's daughter worked for Kamala's presidential campaign in 2019, and because the judge donated to Democrats twice, in particular Joe Biden, who up until recently, before he was thrown out, was Trump's political opponent. Now, Mr. Trump also states that Merchan failed to conduct a proper pretrial review of presidential immunity because Trump said, I'm immune multiple times. The judge said, stop bringing it up, and prohibited Mr. Trump for pursuing interlocutory review of that decision. And this is exactly right. This is all true, by the way. Like, factually, you can't argue with it. And so they say, well, this court does not have jurisdiction to hear Trump's arguments concerning the propriety of the trial. The jurisdiction possessed by the district courts is strictly original, meaning we look at it new. We don't look at what the old people did, what the old case law did, or what the old trial courts did. We just look at it fresh with a fresh set of eyes. District courts may not reverse or modify state judgments, even those containing constitutional infirmities, because to do so would be an exercise of appellate jurisdiction and not federal removal jurisdiction, right? If you're unhappy with the trial, appeal it, which Trump is, and it's going nowhere because it's also the New York courts, which are very happy with all these outcomes and this rigging. Now, instead, they say the proper recourse for parties seeking to remedy alleged errors made during a state trial is to pursue a state appeal, or at the highest level, to go to the Supreme Court of the United States, which is where Trump's going to have to go. It would be highly improper for this court to evaluate the issues of bias, unfairness, or error in the state trial. They say that's not what we're here for. Okay, if Trump's unhappy with the trial, he should go to the Court of Appeals in New York, and then to actually in New York, the Supreme Court is called the Court of Appeals. So, right, work his way up to the top there, and then once the Court of Appeals, aka the state Supreme Court, says no, then you go an appeal from them to SCOTUS. Now, those are issues for the state appellate courts, and so accordingly, only the second ground ground argued by Trump deserves attention. And so if you're unhappy with the lower level trial, take it up with the state courts. Now, similarly, they say, so let's talk about immunity and what the Supreme Court said, because we've made the argument that Trump has immunity because of the fact that they brought in a bunch of official conduct into the conversation, presented it as evidence at trial. So they say in Trump, in this immunity case, right, the Supreme Court held that a former president is entitled to absolute immunity from criminal prosecution for actions taken in exercise of his core constitutional powers. So if the president, it's delegated, right, if it's delineated, you can do this, you can't be prosecuted for that because it's explicitly your right. So that's bucket one. So this is what the immunity decision said. So that's bucket one, absolute immunity for bucket one. Now, this doesn't mean, and you hear this stupid talking point from MSNBC regularly, I guess Trump can just murder people. No, that's not what this says. Okay, read it. Or bucket two, to at least presumptive immunity for acts within the outer perimeter of his official responsibility. That's bucket two. And to no immunity for his unofficial acts, right? So that's if you shoot somebody on Fifth Avenue or whatever, you're not allowed to do that. So you don't get immunity for that. So criminal courts trying former presidents are required to evaluate his actions to distinguish official from unofficial conduct. Now, guess what? Criminal courts like Mercan's didn't do that. They didn't do that. Or they didn't do it through an evidentiary hearing. Let's see what they say the proper evaluation is. Now, the outer perimeter of the former president's official responsibilities extends to those actions that were not manifestly or palpably beyond his authority, which is broad. Okay, so it's like if it's not obviously not your responsibility, like you don't have that power, obviously, then it's probably immune. So it's very powerful. Now, private schemes with private actors, unconnected to any statutory or constitutional authority or function of the executive, are considered unofficial acts. So if Trump is scheming with Michael Cohen to cover up a porn star situation, unconnected to any authority, then that's unofficial. So let's see what he says. Now, I held in my order before, about a year and 2 months ago, that hush money paid to an adult film star is not related to a president's official acts, which is this judge. Who is this judge? Alvin Hellerstein. Okay. I was like a bro with Alvin Bragg. Okay, they're like first name brothers. You know, I get it totally. All right. So he says, it does not reflect in any way the color of the president's official duties. Now, my holding followed an evidentiary hearing where Alvin Bragg showed conclusively that Trump reimbursed Cohen for advancing hush money payments, including 2 checks signed in the White House by Mr. Trump. Now, I held Mr. Trump had not satisfied the burden of proof to show the basis of removal during that last evidentiary hearing. Now, my holding of hush money reimbursement remains true regardless of who has the burden, whether it's the people or Mr. Trump. Nothing in the Supreme Court's opinion affects my previous conclusion, this is such a joke, conclusion that the hush money payments were private, unofficial acts outside the bounds of executive authority. So we'll see what Trump does with this and whether they appeal this decision. It clearly appears on the face of the notice that removal should not be permitted, good cause has not been shown, and leave to remove the case is not granted. So the clerk shall terminate this. It all stays back down there with Judge Juan Mercan. And so that was happening at the federal level. This is what's happening at the state court level. So this is from Trump's defense attorney going to Judge Mercan. We respectfully submit this letter, all right? On August 29th, Trump, we filed our second removal notice in the U.S. District Court for the Southern District of New York. We read that yesterday and saw the rejection today. We'll transmit a courtesy copy of that to you, Judge Mercan. But look, in order to allow adequate time for the District Court and Bragg to address Trump's recent federal submission, so even they're like, holy crap, you rejected it already? And to avoid the forms of prejudice and irreparable harm detailed in that filing, Trump respectfully requests that this court refrain from deciding the presidential immunity motion until after the district court has resolved this, right? This is all now moot because the court acted so quickly. That is the only appropriate course in light of the gravity of these presidential immunity violations that the federal court just said we don't see any at all, that occurred in this court and the resulting harm to the institution of the presidency, as well as the significance of the Supremacy Clause and other concerns raised in the second removal notice. Moreover, as indicated in the second removal notice, the court may not sentence Trump while this removal litigation is pending because that would result in a prohibited judgment of a conviction, which would not be appropriate if he has immunity. And so for the reasons set forth in our prior motion, there's no undue prejudice to any valid interest if you just wait for the federal courts to review this. And so as you can see, they're even shocked. Like, how'd they get this done so quick? In response to that adjournment request, Bragg denied not provide any meaningful opposition, and they hardly suggested that Your Honor's current schedule was necessary or appropriate. For example, Bragg acknowledged in their August 16th letter that the schedule would present appellate courts with the impossible task of deciding certain issues of first impression in one day. Supreme Court also made clear that this is going fast. So the first post-Trump scheduling conference in that case will not even occur till September 5th, 2024 in the District of Columbia case. And Jack Smith's office announced this week that they had obtained another superseding indictment. Now, those prosecutors' unsuccessful efforts to purge the taint of presidential immunity by obtaining a new charging indictment instrument from an entirely different grand jury are the same as what's happening here. Okay, Trump is making the same argument, just like we did the compare and contrast with Chutkan pausing the underlying pretrial process for immunity. Jack Smith, his original prosecution and indictment was so bad, he had to do it over again. So Alvin Bragg needs to do the same thing. And to be honest, the federal courts, I think Jack Smith, it's a sneaky thing he did to file that superseding indictment. Like, oops, I'll just take out the bad part. No, the entire thing is bad. Jack, you're predicating the whole thing on immune conduct. But here, it should also be the same. Bragg should be forced to retry him again, re-indict him, strip out all the immune stuff. Are consistent with Trump's position in this case that Bragg's use of official acts evidence requires dismissal, saying there is no good reason at all to sentence President Trump prior to this election. No reason. And if there is to be a sentencing at all, or to drive the post-trial proceedings forward on a needlessly accelerated timeline relative to the manner in which similar issues are also being addressed by Jack Smith, illegal prosecutor. And so accordingly, the court should hold a presidential immunity motion in abeyance, adjourn the sentencing, and refrain from issuing any substantive orders until the second notice is resolved. Now, at the state level, Bragg responded. So this is what Bragg said in response to Trump's motion. That one just went to Judge Merchan. Again, at the state level, the same court that did the trial. They said, all right, we know Trump filed a second removal request. They say federal law is clear that proceedings in this court don't need to be stayed until they decide on removal. So when Trump is trying to remove this, you should still sentence him. The court can and therefore should determine Trump's prior motion and the upcoming schedule now. In other words, don't postpone this. Now, in addition, notwithstanding defendants' effort to mischaracterize our position remains exactly as we indicated. We defer to the court on the appropriate post-trial schedule that allows for adequate time to adjudicate while also pronouncing sentencing without unreasonable delay. All right, so they're telling us that the federal court, even though they've decided very quickly, they're saying, well, if the federal court takes 2 weeks to decide this issue, we should still move forward because they haven't removed it yet. Until they take it away, it's ours. And so as we saw previously, they're saying, well, Judge, we're not going to tell you how to run your calendar, but we want the sentencing to happen without unreasonable delay. We note the concerns that Trump expresses about the timing are a function, they say, we note that Trump's concerns are a timing of his own strategic and his dilatory litigation tactics. This second notice of removal comes nearly 10 months after Trump voluntarily abandoned his appeal from his first unsuccessful effort to remove this case. Well, that's because we have a new Supreme Court decision that just dropped. Hello. 3 months ago, after he was found guilty by a jury, and nearly 2 months after the defendant asked the court to consider his prior motion. Okay, well, you forgot. Hello, Matthew Colangelo, Biden prosecutor who worked for Biden and Harris. You don't mention the SCOTUS immunity case tucked away in there, nor does the pretrial schedule in Trump's federal prosecution for corruptly interfering with the peaceful transfer of power in 2020 have anything to do with the post-trial schedule in this case. Man, Matthew Colangelo sounds bitter. He's probably upset that his BFF, Jack Smith, is not a real prosecutor and is having that case just collapse all over the place. Colangelo's a buddy, Jack Smith, not even a real boy. And Matthew Colangelo is trying to keep this train on the track. So we have more out of New York. So more rigged activity in New York. Watch this one. Trump is appealing his E. Jean Carroll verdict. This is the grab him by the purse case, allegedly Bergdorf, E. Jean Carroll in a Bergdorf room. And what happened is Trump is appealing this verdict. And guess who is going to be on the appellate panel? Well, we've got several judges on there. As you can see, they're listed here. Chin, Carney, Perez, all on the docket. And look who appointed these people. Denny Chin was appointed by Bill Clinton and Barack Obama. Susan Carney was appointed by Obama. And Myrna Perez was appointed by Biden. Oh no. Isn't that just terrible? What bad luck that is, huh? So Trump's appeal in the grab him by the Bergdorf, E. Jean Carroll. Remember her? She was that woman who had painted her trees blue in the forest for some reason. Yeah, that's her case. And the jury jury actually found that she was, in my opinion, a liar. She said that she was arred, and the jury said, no, you weren't. They just said you got grabbed by the purse. So they didn't believe her on that first count. I'd say that's kind of, well, they said, no, you lied about that. You testified differently. You said this happened and it didn't happen. And so they just gave her, you know, a little gimme because they hate Trump. Now it's going up on appeal, and Trump's going to have those 3 judges, a jury of his peers. In addition to that, we know Jack Smith re-indicted Trump, and so Trump is going to have another arraignment. This is in the District of Columbia, Judge Chutkan's courtroom, and the president is now signing off on a waiver of his appearance. Says, I, President Donald J. Trump, the above-named defendant in accordance with federal law and rules, do hereby waive my right to be present at arraignment at my new indictment from the illegal Jack Smith, who's not even a real prosecutor according to a federal judge. And I authorize my attorneys to enter a plea of not guilty on my behalf to each and every count of the superseding indictment, which are the same charges. I further state that I've received a copy of the superseding indictment and reviewed it with my counsel, signed by President Donald Trump, submitted in a court filing, also with his attorneys Todd Blanche and John Lauro. So, big day. A lot of new filings, a lot of new activity, a lot of stuff happening. The clock is ticking. We now know Trump's case is going to be staying at the state court level. We'll see what Trump's defense attorneys have to say about it, if they'll be appealing this like they attempted to do on the last one, saying, Judge, your justification for denying it in the last one was a misapplication of the standard. You said that you did a good job putting things into bucket 1, 2, or 3, non-immune, presumptively immune, and absolutely immune. You didn't. You did a bad job. All the stuff you said's in bucket 1 should be in bucket 2 or 3, and so we'll actually apply it. The evidence should have never even been accepted, right? Evidence comes in, the judge says, well, I'll hear about that. He should have said no. Nope, can't talk about that. Should be precluded because that's obviously immune. And so we're going to be here continuing to cover this case in particular and the rest of the Trump litigation, the ballot litigation, election stuff. Thank you, my friends, for subscribing. Thank you for joining us here today and for coming on back here on the next one. We'll see you back here in the process.